para el Instituto Colombiano de Responsabilidad Civil y del Estado. En realidad es un honor contar con el profesor Michael Green hoy. Hace unos años decidimos hacer una apuesta arriesgada de comenzar una especie de diálogo poco a poco, desigual ciertamente, con algunos académicos del Common Law. Hace 4 años tuvimos en el Congreso a Jane Stapleton de Australia y a Greg Keating de Estados Unidos. Le habíamos insistido ya en ese momento al profesor Green que nos acompañara, no fue posible por razones de agenda. Y en este momento, para este Congreso, con alguna antelación y además gracias a la generosa ayuda del profesor Miquel Martín Casals, el profesor Michael Green aceptó venir con nosotros a pesar de las limitaciones de idioma. Como él no habla español, se lamenta mucho no participar en las demás conferencias. Sin embargo, ha aceptado generosamente venir a compartir esta charla que estoy seguro resulta de mucho interés y les voy a explicar por qué. El profesor Michael Green es Juris Doctor de la Universidad de Pensilvania, Bachelor of Science de Tufts University, ha sido profesor visitante de distintas universidades de Estados Unidos, entre las cuales están Cornell y la Universidad de Nueva York. Es autor de numerosas publicaciones sobre derecho de daños. A este tema le ha dedicado prácticamente toda su vida académica, tanto en Estados Unidos como en Europa. Es miembro del American Law Institute y en el marco de las actividades del American Law Institute fue uno de los redactores del Restatement of Tort, al menos en la tercera versión, y sus intereses han estado dedicados a la metodología del test Daubert para la prueba de la responsabilidad médica, el impacto de la reforma sobre los deberes del poseedor de la tierra en la responsabilidad. Actualmente es titular de la cátedra Bess and Walter Williams en Wake Forest University en Winston-Salem, en Carolina del Norte, y además es miembro del European Group on Tort Law. La presentación que él va a hacer la ha titulado The Legos of Tort or Non-Contractual Liability, los legos de la responsabilidad civil extracontractual, a partir fundamentalmente de la experiencia de los Restatements of Torts. Él nos va a explicar a nuestra práctica jurídica en qué consiste eso de los Restatements y cómo se articula en el derecho estadounidense. Para su comodidad, la presentación que se va a poner está en español, aunque él va a hablar en inglés con la traducción que ustedes tienen. Professor Green, please feel welcome to Colombia, to Medellín, and to our institute.
Buenos dias. I am honored to be here, and I thought that to demonstrate my gratitude at being invited to this distinguished group of Spanish-speaking lawyers who are interested in torts, I would deliver my talk in Spanish. Then I recalled a biography I read a number of years ago about Winston Churchill. Churchill prided himself on his ability with foreign languages. So Churchill had been invited toward the end of his career to give a talk in Paris, and he decided that what he would do would be to deliver his talk in French. He began by observing, as I look back upon my career, I find it is divided into 2 principal parts. At that point, he noticed a stirring in his audience. Many had smiles on their face or smirks. A few burst out into laughter. And most of the rest of the audience were exchanging glances with each other. So he then stopped and translated back to himself what he had just said, which literally was, as I look back at my large rear end, I see it is divided into 2 big globes. Churchill finished his speech in English, and I think I will do the same. I have a confession to make. I come from a country that is a common law country, which has a very different legal system from yours. To sketch briefly, some of you may appreciate this. To sketch this out briefly, common law systems rely on an adversarial approach to litigation, in which the parties, rather than judges, take the lead in developing and presenting evidence. Judges are passive, simply ruling on disputes, but not gathering or presenting evidence. Sources of law are decided cases. This is common law. We have codes, but many areas of law are populated only by court decisions. So we have judges who make law, and we recognize that that's what they're doing. Those case decisions are followed by a principle we call precedent or stare decisis. So once a court decides a matter and writes an opinion, that law stands as the law until a judgment is made that different conditions require a different law. There's another important difference between our countries that I want to tell you about. The U.S. uniquely in the Western world relies on a jury of 6 to 12 lay people in civil cases, in criminal cases as well. Juries are charged not only with finding historical facts of who did what to whom when, but also making judgments about whether, for example, in tort, a party has acted wrongfully, or given that she did, whether she should be responsible to pay damages for the plaintiff's harm. So in our legal system, juries play a very important role in determining the outcomes of cases. Judges, by contrast, they play a role, but their role is to determine matters of law rather than matters of fact, or even judgments like whether there was wrongful conduct. So at this point you may be wondering, why is this character who comes from such a different legal system and culture, whose laws reflect this aberrational procedural device of juries as decision makers, why is he here talking to us about tort law today? It's even worse than that. When I was first asked to speak, I was asked to talk about the basic principles of tort law rather than a specific topic. At an organizational meeting 25 years ago, there's an organization in the United States known as the American Law Institute. There was considerable sentiment expressed at that meeting for starting a new restatement. I'll explain restatement in a bit, but there was planning for a new restatement of torts, and there was considerable sentiment that we should start with basic principles. I was skeptical at the time. I believed that tort law was not built from the bottom up, but rather haphazardly, with a piece of this from here and a phrase from there, but nothing that resembled intelligent design or even foundational principles. This was my view of tort at the time. So at this point, I expect that many of you are looking around at how to make a quiet exit so as not to have to waste time continuing to listen to this alien who comes from a foreign legal system and who just confessed he doesn't believe in the topic that he's speaking about. give me a few more minutes to try and persuade you that I may have something of interest for you. To begin, my views about the foundations of tort law have changed. They changed as a result of many years working as the reporter for the restatement of torts. Let me explain what a restatement is by identifying another difference between our countries. The U.S. is a federal system of government with shared sovereignty between the federal and, you call them department, we call them states. Common law is predominantly left to the 50 states, the 50 departments in the United States. This resulted in the late 19th century and early 20th century when tort law was growing because of the Industrial Revolution, in much inconsistency and inclarity in tort law as each of 50 different states developed their own tort law. There was commonality, but there was much difference and much confusion about what tort law was in any given department. Aiming to solve this problem, a group of the foremost judges, lawyers, academics in the United States formed an organization in the 1920s called the American Law Institute. American Law Institute probably should have been the North American Law Institute, but they weren't thinking about the other America that existed. The purpose was to try and provide greater clarity, consistency, and a bit of progressivism to the law in the United States. It might be thought of as a private equivalent of a law reform commission, which are governmentally established groups to examine existing law and make recommendations for changes. The ALI has done its work through what are called restatements of the law. These are books that contain rules of law in the area that the restatement talks about. So there are restatements of torts, there are restatements of contracts, there are restatements of property, and many other areas of law. These restatements have no official authority. They're done by a private, nonprofit organization, and they provide no mandatory rules. But what they do is make recommendations to judges who are free to adopt them. And where courts find them helpful, they do so. And so today you find in the United States much law that is derived from these restatements that have been produced by the American Law Institute. They have a great deal of credibility. Courts look to them. Don't always, but very often where law is unsettled, they will accept the rules that are provided in a restatement. Another aspect of my trying to convince you to stay here is to tell you that I've been fortunate for over 15 years to work with a group of European tort academics. This is the European Group on Tort Law, which has published a European analog of the American Restatement of Torts. It's titled Principles of European Tort Law. Most of those Europeans who participated in that group come from civil law systems, including those that were derived from the Napoleonic Code, as I understand yours was. The building blocks for tort law contained in the European and the American, in the European Principles of Tort Law and in the American Restatement of Tort Law are remarkably similar. Some aside from one matter, duty, which I'll speak of, the basic principles, European and American, are remarkably the same. And those are the ones that I want to speak about today. Building blocks that I think tort law in any country, in any system, if we have tort law, there are other ways of dealing with particularly accidental injuries. New Zealand has a government compensation system for accidental injuries. That's not tort law. But if we're going to have tort law, I propose to talk about the basic things that every system must have. And in the process, I'd like to explain current controversies and difficulties confronted, at least in US courts. Let me begin briefly with the theory of tort law. What is the overarching principle? Because maybe that will help us in trying, at least at the margins, to determine what tort law, how tort law should rule. In my country, there is in my country, there's this a huge fight. There's a war going on in the United States over what the theory of tort law is. On the one hand, we have people who insist that it is about corrective justice, it is about the two parties, and whether one party has done wrong to another and therefore should pay. This is a very closed system, injurer, victim, wrongdoing, compensation. The other view is quite different and has been brought to us by the economists, who think that what tort law is about is, although it's private law, it serves a public function. And its public function is to deter antisocial conduct that society does not want to have occur. And the way it deters is by imposing sanctions in the form of damages that the wrongdoer is required to pay, and the wrongdoer knows she will have to pay, so that she will not take those actions in the future, and others won't also, because they're aware that they will be required to pay for the consequences of that conduct. Who is right? Well, neither of them are, in my view. There's no single explanatory theory for tort law, no intelligent design that provides the guiding principle to provide tort rules. Rather, tort law is a polyglot that reflects fairness, deterrence, and other goals, such as compensation and administrative efficiency, and would shift over time with cultural, social, and economic change. Today, continental legal systems, my friend Miguel Casals, they're much less comfortable with deterrence as a goal of tort law. They acknowledge it, but it's not front and center. I have a sense that that may be similar in your country. Deterrence is secondary to fairness, to corrective justice. Okay, so what are the basic building blocks of tort law? First, there are different standards of culpability that are employed in determining liability. There is intentional conduct, and by that I mean conduct that is engaged in with a purpose or with substantial certainty that it will cause harm. Of course, this is assault and battery and the intentional torts. There's a second level of culpability, negligence, or conduct that poses unreasonable risks. This is not conduct that is intended to cause harm, but this is conduct that poses risks that society deems unreasonable and for which the party who acts in such a way has acted wrongfully or negligently. And finally, there is non-faulty conduct that is not culpable, nor are we interested in deterring it. But if you engage in it, we expect you to pay for the costs that result. This is the area known as strict liability. If I were to design a chart of tort law, the columns, as you see, would be comprised of those three different standards of liability, and the rows would be comprised of interests that are protected by tort law. Tort law is limited in the interests it protects. Bodily integrity is perhaps the core. Real and private property use and enjoyment is another interest that tort law protects. And emotional upset, when a result of an anticipated imminent harmful conduct, is protected, though other emotional upset is often not protected. For example, sitting through an extremely boring and useless lecture. So types of conduct and protected interests are central to any tort system. There is a colloquialism we have in the United States that says the devil is in the details. The devil is in the details. And what that means is we can have basic understanding of principles of tort law like these. But now when we get down to the nitty-gritty of cases, often these basic principles don't help us resolve cases, and we need to be more specific, the details, in order to figure out how to resolve cases. I'd like to move on to fault, culpa, and negligence, because that's the basic standard for determining liability for bodily injury and property damage. Fault may be used as an umbrella to include both intentionally caused harm, which I mentioned, and unintentionally doing so by failing to conform with the legally mandated standard of care. In my country, we call that negligence. Negligence based on an objective assessment of the defendant's behavior. Let me explain what that means. By objective assessment, we do not permit a defendant to plead that he is weak of mind or not physically dexterous in defense of a claim that he acted with fault. What we look for is what a reasonable, ordinary person would or would not have done in that situation. So it is objective as contrasted with subjective in looking at the individual and his or her capabilities when they were acting. So why should that be? Surely on Judgment Day, we will be assessed on how we did given our initial assignment of attributes that were provided. Has someone acted to the best of the abilities that they were given? And yet tort law does differently. It doesn't consider those attributes in judging faulty conduct. My answer is an often unappreciated aspect of tort law, indeed of all law. It is administrative efficiency. Let's see if we can get there. It is administrative efficiency that is the reason for an objective standard. It is just too difficult, too time-consuming, too resource-wasting to get an accurate measure of any given individual who is accused of fault. And so for the pragmatic reasons, we compromise what we might think are our finest moral ideals by saying we will not try and make that determination. Let me move along to another building block for tort law, and that is causation. I believe your terminology is adequate causation. In the United States, we call the same thing proximate causation. In some other countries, it is known as legal causation. These are largely equivalents, and we must have some notion of causation if we have tort law. Tort law can't operate without causation. This terminology, adequate causation, proximate causation, is confusing and objectionable no matter where and when in the world, or even in the solar system, or beyond, it is used. This is unfortunate, confused concepts in tort law. Why is that? Because these terms combine and thereby confuse two very different concepts that for clarity and coherency we should separate. I understand that your courts are beginning to recognize this. I hope our courts in the United States will pick up on this. We've worked very hard in the third restatement of torts to educate courts about the difficulties of adequate causation. One aspect of adequate causation is the factual and historical connection between the defendant's conduct and the plaintiff's harm. That is, without exceptions that we need to discuss here, a purely objective inquiry into what happened, when, and where. It's a necessarily hypothetical inquiry, but it is an inquiry into historical facts, and purely so. The other, and quite different inquiry, is a judgment or normative matter of whether it is just or appropriate that the defendant should be held responsible for harm that the defendant has wrongfully, factually caused a victim. This is a very different notion, but it is one that all tort law requires. We will not hold all wrongdoers liable for all of the harm that they cause. And so we limit liability. We do it within the umbrella of adequate causation, but this is not about whether you factually caused harm. This is because we think we cannot trace the consequences of all that you have caused forever. And so a much better term for this, which is found both in the European tort principles and in the United States restatement, is scope of liability. We want to remove this notion of limiting liability from causation, because it's really not about causation. What it's about is a policy matter about limiting liability. Maybe your courts will continue to recognize this. Clarity, student understanding will be improved if we move in that direction. Let me just highlight for you some issues within the area of factual causation that have been developing. The European tort law principles actually we wrote a book about these concepts, and they're reflected as well in the U.S. restatement. And I'll just set forth a few of them. One is the idea of proportional liability. So we might, where a plaintiff is unable to prove to the requisite standard of proof that causation exists, they fall short. We might permit recovery on a proportional basis rather than on an all or nothing basis, which is the way tort law is constructed right now. So you may be familiar with the concept of loss of a chance. Loss of a chance. This is when, for example, a physician delays diagnosis of a patient and thereby compromises, reduces the chance that the patient will be successfully treated, but doesn't reduce it enough that it meets the standard of proof for causation. Maybe we could say, well, you have reduced the chance of recovery, and we will permit recovery for that proportional loss of recovery. Now, this might be modifying factual causation, or it might be that we recognize a different harm, a different protected interest, and that is your chance for recovery. And if a 20% chance for recovery is lost, the plaintiff may recover from the defendant for that loss. It has to be factually caused, but the loss of the chance becomes the right that is recovered. We also have problems in the United States with factual causation when we have long latency disease cases such as asbestos, tobacco, and cancer-causing drugs. And often we are not certain about whether the standard of proof has been met. And so academics have recommended, suggested, that proportional liability be imposed, so that if we think that there's a 40% probability that it was the defendant's asbestos that caused lung cancer, we will permit recovery against that defendant for 40% of the damages that would otherwise be available for causing cancer. Let me move on to another basic building block of tort law. All legal systems must decide which harms or injuries it will protect against and which it will not. If I look out at you and I see a large group who are napping, taking a little bit of a snooze, my feelings will be hurt, even more if more of you are sleeping. But hurt feelings are not harms that are protected by any legal system of which I know. And quite sensibly, I do not have a tort claim because these are the ordinary staples of life, small insults that can and should be gotten quickly over, and that we do not want to exacerbate by saying you can go to court, Green, and sue those nappers in the audience. I mentioned previously the idea of loss of a chance of recovery or loss of a chance of cure as being recognized as cognizable injury. These are policy determinations that are made by courts that we will recognize this interest and that tort law will protect against it. We've had a terrible problem with a condition known as pleural plaque. This is a scarring, a change to the body and the lining of the stomach and the lungs. But it causes there's no clinical symptom. You can continue doing everything. It may develop into asbestos disease, but by itself it doesn't cause anything, though we can find it. We can find it with x-rays. Should that pleural plaque, when it occurs, should that be a legally protected interest for which an asbestos worker can recover or not? Another policy determination that has to be made about what tort law protects or doesn't. The final Lego that I want to address is one that I expect you to be largely unfamiliar with because it is a product of a unique American practice. The element oh yes, okay, so that's plural plurality. The element is one called duty. And while it is sometimes casually referred to in continental legal systems, you could scour the principles of European tort law to find the term duty. There is actually a mention about some affirmative duties that exist, but it's not a central principle of European tort law, nor, as I understand it, is it an element of your tort law. You have a duty of care, but that's about the standard of conduct, that is, what is culpa, rather than a separate element, which is whether the defendant has a duty of care or not. That's uniquely American. And it's front and center in the United States. Why such a central role? Because almost uniquely, as I said earlier, among Western, all developed countries, the US assures a right to jury trial, 6 or 12 jurors, in virtually all cases, not just tort cases, contract cases, you name it, there is a right to a jury trial, at least where damages are involved. This came from a deep skepticism about government when our country was formed. This was dissatisfied English people who came over and were not happy with the crown, and that was part of the reason why they came. And so the civil jury is designed to distance law from the government. And the predominant role that duty has, the reason that duty has developed in the United States, is to give the judge control over when a case will be decided by a jury and when a judge will withdraw it from a jury. So it's actually more correct to talk about no duty than to talk about duty, because no duty is invoked in our tort system by a judge who has made a judgment that this case should not go to a jury, and instead that a defendant should not be held liable for what may have been wrongdoing, but for reasons the judge thinks are sufficient. So it's a judicial trapdoor that judges employ, notwithstanding a constitutional right to a jury trial. There's more to be said on this subject, but what I hope to do here is to avoid the fate of a speaker who went well beyond the time that he was supposed to speak, and people became very uncomfortable at how long he went. And he apologized by saying that he couldn't see the clock on the wall, at which point a member of the audience who was not very happy said, "Yes, but couldn't you see the calendar that was there?" Gracias. Mucho gusto.